former Court of Appeal judge of England and Wales, and now a judge of the court, the new international court here in Qatar. I think the problem is more acute than Joshua identifies, because the national court will carry out a balancing exercise between freedom of expression and the various other perfectly proper rights and interests, and it may then make an order. But in recent years, technology has advanced to such a degree that that order, which is confined, of course, to the national jurisdiction of that particular court, may well be flouted by the technology which is developed and by these social networks, such as Twitter and Facebook. The court may make a perfectly legitimate order preventing the publication of some information, particularly the name of a person, maybe to protect a child, or to protect someone's privacy, or to ensure a fair trial to take place in due course, and then that order may be flouted by the publication of that very same information on the internet. What does one do about this? Can the panel help on this at all? I have, you see, ended up with a question.
Shall I answer that? Well, the Lord Chief Justice of England and Wales, who's sitting next to us today, he was asked this question at a news conference quite recently, and he said that just as the law has found a way of dealing with child pornography, the law should be able to find a way of dealing with these technological problems. And it would be, I think this is my gloss rather than what he said, a counsel of despair to say that it's impossible to cope with it. It's difficult, and it may even mean changing the law. For example, in England and Wales, there are restrictions on what you can say ahead of a trial. Those restrictions don't apply in the United States. There are some people who argue that if technology makes it impossible to restrict what the media can say, then maybe we need to change the law and trust the jury's law. I suspect that view would not find favour with the current judiciary. I'm not sure I hold it myself, but it is a view that the law needs to be changed to take account of modern technology. And it is, in practice, to some extent possible to restrict this information. You stop it getting out, and that stops it getting onto the internet. Whereas in the past you might have given it to a limited number of people who could be trusted not to publish it until an embargo deadline has passed, you now say, well, I'm not going to give this information out at all because I can't be sure that it won't be published. I can't trust the world at large. It's imperfect, it's unsatisfactory, but if we are going to find ways of restricting publication for perfectly good reasons, then some thought has to be given to how it can be done. And if it can't be done, well, we just have to accept the times that we've done and change the law.
I think we've run out of time, and I know that there was a show of hands, but we've covered an awful lot of ground this afternoon's session. I thank you again for joining us and staying for the last session. Thank you to the panelists who really shared, being very generous with your wisdom today. I think some